Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. Just a heads up, Brian Kohberger has a hearing today beginning at 12 Eastern. I'll be live streaming that on my channel, so come watch with us. We're going to jump into a new filing in the Donna Adelson trial, but before we get started, you know the drill. If you're on YouTube, don't forget to subscribe, like the video, share it with your friends, and you can ring my bell if you want notifications of when I post new content. Just click that little bell icon. Music fact of the day, the Beastie Boys wrote, "You gotta fight for your right to party," to make fun of other party anthems like "Smoking in the Boys Room" and "I Wanna Rock." I want to go through a filing from August the 12th. So it's not a new filing, but I'm just getting around to it. So it's new for me. And this is about several issues that the defense wanted to address. Now, she does have a very lengthy hearing tomorrow. I believe I heard it's around 3 hours. I'll be live streaming that, so come watch. The first part of this filing is testimony concerning pre-arrest silence. It says, during the trial for Katie and Sigfredo, Detective Isom testified that at Dan's memorial service in July 2014, he asked Donna if she and Harvey would submit to a police interview, but she left Tallahassee without doing so. The testimony constitutes an improper use of Donna's pre-arrest silence under both Florida Constitution and Florida Evidence Code and should be precluded. They cite the State versus Horowitz, which says prohibits use of defendant's pre-arrest, pre-Miranda silence as evidence of guilt. The next section, wealth evidence. During the previous related trials, the state presented evidence through financial investigator Mary Hull regarding bank and investment accounts held by Donna and Harvey and Charlie, as well as their respective businesses. Such evidence has no relevance to the case at hand and is being introduced to inflame and prejudice the jury. Let's be clear. We don't dispute the monies paid to Katie in the wake of Professor Markel's murder were in fact Charlie's money. We do not dispute that the Adelson Institute had sufficient funds to pay Katie bi-monthly. As a result, the state's so-called wealth evidence bears no relevance to Donna's case and is unfairly prejudicial and inflammatory. They cite U.S. versus Bradley from 2011, recognizing evidence of a defendant's wealth may be admissible when relevant to issues in the case, but that use of a defendant's wealth to appeal to class bias can be highly improper and can deprive the defendant of a fair trial. They cite Ryan versus State, which says comments made by the prosecution in its closing arguments, including the defendant came from money, were of such a prejudicial magnitude as to amount to fundamental error. As such, any evidence concerning Donna's personal wealth should be excluded. Hearsay testimony from Jeff Lacasse. The former boyfriend of Wendy has been called to testify in each of the last 3 trials. He claims at various points during the relationship, Wendy made statements to him conveying statements that Charlie made to her. Among other things, Wendy told him Charlie said buying her a TV was cheaper than hiring a hitman, that Charlie said he looked into the possibility of hiring a hitman, that Charlie described the dinner he had with Wendy following Professor Markel's murder as a celebration, and Charlie said he kept large amounts of cash in his home. These statements are hearsay within hearsay, for which there is no exception under Florida law. Additionally, their admission, if Charlie is unavailable to testify, would violate Donna's Sixth Amendment right to confront and cross-examine under Crawford versus Washington. The state should be precluded from eliciting them either through Jeff or through Wendy. There is no probative value to Donna, and any probative value is substantially outweighed by the danger of unfair prejudice. There's a footnote that says, Your Honor may remember in Charlie's trial, the court granted the first part of this motion. However, the state was allowed to question Wendy about these topics, and the state was then able to impeach Wendy by asking the same question to Jeff. That shouldn't be allowed in Donna's case because, unlike with Charlie in the first instance, these matters have nothing to do with Donna, and do not survive a 403 inquiry. The next section, the testimony of Wendy. During Charlie's trial, the state questioned Wendy about the characters and storyline of a fictional book that Wendy authored about human trafficking, name changes of her children, Wendy's willingness to allow Professor Markel's parents to visit with her sons since 2014, and the Markel's successful efforts since 2014 to lobby for the amendment of Florida's grandparent visitation rights law. The substance of Wendy's fictional book, written years before Professor Markel's death, name changes for her children, visitation decisions she may have made in the wake of Professor Markel's death, and legislation enacted in response to his death have no probative value to the question this jury will be asked to decide: Donna's guilt or innocence on the crimes charged. The probative value is substantially outweighed by the danger of unfair prejudice and should be excluded. Jailhouse recordings, our favorite topic, y'all. The state will likely seek to introduce recorded conversations between Donna and Charlie while he was held at the Leon County Detention Center following his conviction last fall. While Donna's statements may be admissible under Florida law, Charlie's statements are hearsay, for which there is no exception under Florida law. Charlie's statements are highly inflammatory, posing a significant danger of unfair prejudice for Donna, and must be excluded. They maybe are referring to the population there in Tallahassee that Donna and Charlie were bashing, or the jury that found Charlie guilty. Neither were happy with their verdict, of course. The next section, autopsy photos. During Charlie's trial, the state was permitted to introduce 10 separate exhibits, 2 X-ray images and 8 photographs from Professor Markel's autopsy, along with 3 photos of Professor Markel after the shooting but before his passing. In Smith versus State, the Florida Supreme Court has held autopsy photos are admissible if they're relevant and not so shocking in nature as to defeat the value of their relevance. They cite another case which says a photo of a deceased victim must be probative of an issue that is in dispute. Here, Donna doesn't dispute the fact, means, or manner of Professor Markel's death. Any probative value of the autopsy photos is substantially outweighed by their prejudicial effect, and we ask they be precluded. Again, tomorrow, August 30th, 9 a.m., we have a lengthy hearing for Donna. Come watch with us. There's also a pre-trial hearing that is set for September 12th. Again, that's at 9 a.m. So that's the latest filing in Donna's case that I wanted to go through. I mean, we're getting so close to trial. We're just a few weeks out. Right after Donna, we go into Sarah Boone. So we got some busy weeks coming up. I don't know about you guys, but I am ready for Donna's trial. I'm keeping an eye out. So if anything else drops, I will do a quick episode on that. Hope you guys have a good rest of your afternoon. We will see you soon.